As you know, monism prioritizes the desirability of a formal international legal order to establish the rule of law among nations, and that would include in relation to environmental law. And dualism prioritizes the notions of individual self-determination and sovereignty at the state level. So I'm just wondering whether you have detected a difference in the treatment of states' obligations under international law to protect forests, depending on whether the legal system is based on dualism or monism. For example, in Barbados, for the most part, for international agreements and whatnot, even though we try to follow our international obligations, strictly speaking, they don't become law until they're enshrined in legislation. So I'm just wondering whether you detected differences in how states treat environmental issues and issues related to forests, depending on whether they come from the dualist stream or the monist stream. And if there are differences, what are they? And what measures would you recommend to redress any differences in order to ensure that all states comply with their international obligations?
Yes, we have detected a difference in the treatment of states' obligations under international law to protect forests, depending on whether the legal system is based on dualism or monism. But we also realize that the situation is more complex than that. Would you like to point out that we heavily based our next part of the answer in the Oxford Handbook of Comparative Environmental Law, helped us so much in this process. Due to these distinctions about the acceptance and the integration of international law into the domestic system, the treatment of states' obligations under international law to protect forests is different. In monist countries such as the United States, these obligations can be applied more directly upon its ratification and promulgation. On the other hand, for dualist countries such as the United Kingdom, the ratification of the international treaty does not automatically entail an obligation for the state, being also necessary to transform the provision of the treaty into national law, incorporating it in domestic level. For that, the process usually is more complex to engage the obligations depending on more steps of discussions and negotiations. But we also realize that the situation and the engagement are even more complicated than the existence of single or distinct orders. For example, customary law is often directly applicable without legislative implementation, including in dualist countries. And despite the recognition for one approach, in fact, some countries adopt evident contrary theory for some issues. Germany, considered a dualist state, never transposed the word cultural and natural heritage in its domestic law. In Brazil, according to the academic article, Is Brazil Dualistic? From the Academic Journal of Legislative Information, doctrine strives to classify the predominant orientation of the country's judicial, legislative, and executive authorities. The Brazilian Supreme Court has already expressed its understanding that Brazil adopts a dual position, moderate dualism, making some considerations and specifications for treaties that involve human rights. In the judgment of Extraordinary Appeal 466343 from São Paulo in December 2008, the Supreme Court understood that in spite of its dualistic approach, the International Human Rights Treaty signed by the country and not internalized by the specific legislative procedure has a higher hierarchy than ordinary law. Therefore, The approval of an international human rights treaty automatically stands a status of superlegal norm above ordinary legislation and below the Constitution. Moreover, this kind of treaty, after the procedure to incorporate in the national system, became a norm with a constitutional status. We recommend two measures to redress this difference and challenge to ensure that all states comply with their international obligations, based both on our thoughts, but also on the Oxford Handbook of Comparative Environmental Law. First, environmental norms can be given a special status via the human rights route, when international human rights treaties are integrated in the constitutionality block. Second, a more direct but less common possibility consists in recognizing that international environmental norms per se are part of the constitutionality block. The Supreme Court of Justice of the Dominican Republic did not close the door to this possibility. Indeed, after having delineated the content of the country's block of constitutionality, it analyzed the obligations arising from inter alia environmental and natural heritage conventions, as well as soft law environmental instruments. By not declaring the case to be inadmissible, the court implicitly considered that these conventions were part of the block of constitutionality.
That developed state parties have the obligation to minimize and address loss and damage caused by climate change under the Warsaw International Mechanism on Loss and Damage and the draft articles on the allocation of loss in case of transboundary harm. And second, that state parties have the obligation to protect the right to life in the context of climate change.
One of the limits of international law is often said to be not only is it hard to regulate state behaviour, but also the behaviour of private actors. Do you believe the UNFCCC, if a statement such as you are seeking is made by the ICJ, can that in any way deal with private actors? Of course, I'm thinking of large emitters of greenhouse gases. Does the UNFCCC provide a mechanism in that regard?
Your Excellency, the UNFCCC being a framework convention provides a way for the greenhouse gas, provides a provision for the greenhouse gas emissions to be reduced. However, there are also other treaties like the Paris Convention that specifically deals with the current problem, Your Excellency.